behalf, Pat.
Good morning. Welcome everyone to the Practical Strategies webinar. This is our 8th webinar, and we're pleased to inform you that we have at least 375 registrants today. For those joining us, if you look to the left of your screen, there's an area where you can ask a question which will be directed to me and then directed to the panel. We'll try to get to as many questions as possible. Today we're looking at some recent amendments in auto insurance law for healthcare professionals, and we're going to touch upon a number of different issues that are pertinent to people's practices, and hopefully some of the tips from our panel today will help. Sitting next to me is Michelle Bowman. Michelle's an accident benefit coordinator from Oatley, Vigmond. Thanks for coming, Michelle. Alana Strilich is next to Michelle, and she's from McLeish, Orlando, and she too is an accident benefit coordinator. Sitting directly behind me, we have Amy Cullingford, and Amy is a senior insurance adjuster from the Toronto Dominion Insurance Company, which she's been around for over 10 years. And thanks, Amy, for joining us, and thanks to your company for allowing you to join us today. And next to Amy is Jim Vigmond. Jim is a partner at Oatley, Vigmond. Next to Jim is Allison Burson. She's a partner at McLeish, Orlando. And next to Allison is Roger Oatley, a partner at Oatley, Vigmond. I'm Patrick Brown, and I will be your moderator today in dealing with today's seminar. The one area where we're going to start out with, and this is directed to Allison, is recently there has been changes to the SABs as it relates to attendant care and incurred expenses. The changes occurred, I believe, in February. And Allison, I understand you're going to help us in going with an overview of the changes, and we're going to move forward from there.
Thanks, Pat. The changes that came about in February of this year through regulations to attendant care, I think, are going to be hot topics today, and there's going to be a number of people commenting and probably a number of questions coming in. But I'd like first to give a brief overview of what the attendant care and housekeeping benefits look like for injured persons involved in motor vehicle accidents pre-September 2010, so that we understand ultimately where we're at today with those benefits and practically how we move forward. So as most of you know, pre-September 2010, attendant care benefits and housekeeping benefits were available to injured persons involved in a motor vehicle accident, whether they suffered a catastrophic or non-catastrophic injury. So essentially establishing what amount of attendant care or housekeeping was needed was done and is still done by an occupational therapist who does the assessments in using the Form 1. The rates are set in the Form 1. And ultimately, pre-September 2010, if you suffered a non-catastrophic injury, the cap on those benefits per month was $3,000, and a catastrophic injury, it was $6,000, even if the assessment was much higher. And housekeeping benefits as well were available to injured persons, whether they suffered a catastrophic or non-catastrophic injury, up to a maximum of $100 a week. Of course, the limit for the non-catastrophic injuries, it could only be claimed up to 2 years after the accident, which didn't occur, didn't have the same limits with people injured who were catastrophically injured. And the definition ultimately with respect to incurred or how these benefits were paid was very liberal. And ultimately, once the Form 1 was completed and there was a need for attendant care or housekeeping, if those services were provided, whether it be by a professional or a family member, and that family member, it was very clear in the SABs, didn't have to have any experience with providing that type of care in the past, then that was deemed to be incurred and the benefit was payable. And the benefit was payable in accordance with the Form 1. So if the Form 1 had an amount for a catastrophically injured person at $7,000, then the max paid would be $6,000, and that went directly to the person that was providing the service. So now we're dealing come post-September 2010, and there obviously were limitations put on those benefits. The first was the housekeeping benefit was taken away for people that didn't suffer non-catastrophic injuries. And probably one of the most important and controversial changes came with what was the definition of incurred now. And incurred was ultimately qualified for both attendant care and housekeeping. And once a need was set out in a Form 1 for these benefits, a person who was providing those services, who was a non-professional, and I'm speaking mainly family members who had stepped up to the plate and decided to be the full-time caregiver for someone that needed it after an accident, had to not only provide the benefit to the injured party, and there was an obligation that they would be doing it for payment, but also they had to show that they sustained some sort of economic loss as a result of providing that attendant care and housekeeping. And that essentially was how the regulation or the SABs came into play with determining what was incurred. But obviously the big debate came after that was, what is economic loss? And a number of family members were submitting claims for attendant care they provided to injured family members, and these were being denied based on different interpretations of what was considered an economic loss. So between September 2010 and February 2014, where a regulation came in place with respect to economic loss, there were two decisions that came out that helped with the interpretation of what economic loss was. The first was Henry versus Gore, the Ontario Superior Court of Justice decision of Justice Ray. In between that being appealed to the Court of Appeal was Simser versus Aviva. It was a FISCO decision by Arbitrator Lee. And ultimately, Justice Ray's decision was upheld at the Court of Appeal. But probably the most talked about decision was Henry versus Gore. And very briefly on those facts, in that decision, Tyrone Henry suffered a catastrophic injury in a motor vehicle accident. His attendant care needs were assessed to be approximately $9,500 per month. His mother quit her job where she was earning a salary of approximately $2,100 a month to care for her son. And she was claiming the attendant care benefit in the amount of $6,000 per month. So ultimately, the insurer argued that the amount that Mrs. Henry should be paid was $2,100 a month, and the lawyer for Tyrone was claiming it should be $6,000. And Justice Ray, as we all know, said ultimately economic loss is a threshold. It's a threshold that once there is a concrete economic loss, in which case Mrs. Henry had provided that concrete economic loss of $2,100 a month, that gets you over the threshold to be able to claim the amount in the Form 1, which she was claiming at $6,000, not the $2,100 a month. And ultimately, Justice Ray, which Arbitrator Lee agreed with, although he came to a different conclusion, he said, you don't calculate the quantum of the economic loss, there just needs to be a concrete economic loss. So that brings us to a regulation that is a hot topic today that came in February 2014 that essentially clarified the economic loss with respect to attendant care and eliminated Justice Ray's decision for economic loss, at least for attendant care only. And in very short, it says where the attendant care is being provided by a non-professional family member in most circumstances who is in the normal course of providing those services, the amount payable shall not exceed the quantum of the economic loss sustained by the provider during that period. So very simply, the decision of Henry versus Gore, had that accident happened after February 1, 2014, Mrs. Henry would be entitled to $2,100 per month in attendant care. And if you calculate that out to the injuries and the amount of attendant care that was being required in that particular situation, the hourly rate would be just under $3 an hour. So that turns to my next topic, is what are the practical implications of this regulation? And I'm going to talk briefly on that, and Roger's going to talk briefly on potential strategies. But the practical implications for families is a significant financial burden now is placed on them, and more so when the person suffers more serious or catastrophic injuries. When you have situations where families aren't able to provide any concrete loss of income, they're going to be providing that attendant care completely without pay. In those situations, the unpaid labor they did around their home before the accident and outside the home, they're going to be leaning on other family members or neighbors to perhaps help out in those situations. And in certain situations, we've even had families ask, well, if I pay for someone else to do X, or if I pay for someone else to do Y, am I going to be getting that back? Is that considered the economic loss? And I think that's going to be somewhat a discussion here, but, first of all, can families afford to pay third parties for those services in the hopes that they'll be paid back as qualifying an economic loss or be forced to pay back? And can they wait that long for a decision in that area? You're also going to see families using outside agencies more often for attendant care in these situations. But what that practically means for a family is going to really vary, because if you have a situation where a family and an injured party lives in a remote location, a lot of those funds are going to be used up in travel. And in addition, the market rates for that type of professionals to come out is approximately $23 an hour, and the subs rates are about $13 an hour. You also have the situation that has been discussed, I know, at other webinars, is that injured persons generally don't want strangers providing that care, especially in the evenings or overnight. They want family members to be there or someone that they're more comfortable with, and most of the time that will then fall into the category of a non-professional providing those services. So ultimately, the irony of this regulation that's come in is that, in my opinion, the burden's going to be much greater on families in terms of providing care for injured person, especially where significant attendant care is required, which ultimately is the opposite of the purpose of these benefits.
Thanks, Allison. And Allison had mentioned, Roger, your office deals with a lot of these families that are going through these events with somebody seriously injured. What are some of the practical solutions that you're offering through your office in order to deal with these types of situations?
Well, it's a tough one, Pat. Let me back up just a little bit. As Allison was saying, there was a real tension in the system here, because typically we'd see families where, for example, dad was catastrophically injured and unable to work, and receiving an IRB that it was a very small portion of his actual income loss. And so mom would pack in her job to provide the attendant care. And because of the Form 1, the family would regard themselves as receiving $6,000 as an attendant care benefit. But really, for them, on a practical level, it was not only covering the wife's income losses, but it was topping up what the husband was losing too. So the family was unquestionably living on the attendant care benefit. Now, the tension, on the other hand, was that the insurance industry was saying, that's not what we intended. We intended to be paying for attendant care. And why should we be paying $72,000 a year for that spouse who gave up a $35,000, $40,000 a year job? There's something very wrong here. So, as often happens, we had a system in which there was this tension, and now finally the government has made it clear on behalf of the industry, as Allison said, that in my example, it's only the spouse's lost income of $35,000 or $40,000, whatever it is, that will be reimbursed if the spouse is going to provide the attendant care. Now, clearly, this throws that family into economic crisis. Unhappily, there is no solution. That is the way it's going to be, unless there is some testing of the legislation that results in it effectively being reversed, which none of us in our firm see happening. What we have really been forced to tell our clients, and we're telling them in no uncertain terms, is if you want the insurance company to be paying $6,000 a month, the full benefit for attendant care, you've got to hire a professional to do it. Now, if you're watching this and you're somebody who provides attendant care, Allison's right. That's going to inure to your benefit. What it's going to do is force family members to stay in their jobs, to try and make ends meet, retain professionals to provide attendant care, and the benefit will be payable at the full $6,000. So the net savings to the industry, in our estimation, will not be very much money, because law firms like ours who know what they're doing are going to be making this recommendation, and clients are going to be following it. Now, Michelle, one of our accident benefit specialists who's here, tells me that in some circumstances where families have just been absolutely insistent that they provide the attendant care within the family, and if, going back to my example, the spouse has an income of only $35,000, that gets paid on a periodic basis to the family. And Michelle tells me that what she is suggesting is that the family hires a professional, probably a PSW, to the extent of the remaining benefit. So it's topped up effectively at $6,000. The housekeeping is another issue. I don't know whether you want me to go there, Pat, but very briefly, what I'm told some of our accident benefit specialists are encountering is insurers saying, well, now you've received your full economic loss. There can't be any more that you can attach to your housekeeping benefit claim, so we're refusing that on the basis that there's no further housekeeping loss. So families are going to have to turn around and hire professionals to do the housekeeping too if they want to have the benefit paid. And a new one that's coming up, Michelle tells me this morning, is she's had at least one company indicate that what the family is going to get is the net economic loss, not the gross. So it's the after-tax loss that the company's going to pay, which I'm sure will generate some litigation. So that's not very helpful, Pat, in terms of telling you out there what the strategies are, but that's the way it is.
Wow. Yeah, and unfortunately, Roger, that is the way things are. Hopefully, there's still opportunity for the government to change that legislation and ensure that family members are provided the right compensation for their services. This leads nicely into a question to you, Amy, from the insurance side of things. How are you dealing with the attendant care issue at your company and in relation to incurred expenses?
So I'll talk a little bit about attendant care and the incurred expenses and economic loss before February 1st, 2014 and after February 1st, 2014. So before February 1st, 2014, if a professional attendant care company or a PSW company was coming in to provide the services to a client, we would be billed for the $2,000, let's say, from that specific company directly to us, and we'd issue the invoice to that company. We would then top up the client or pay out the difference up to the Form 1 amount and within the applicable limits in accordance with the SAB. So if, for example, if the attendant care company was billing the insurance $2,000 a month for attendant care services, the Form 1, if it was listed at $7,500 per month, and this was a catastrophic claim, the maximum monthly amount for attendant care would be $6,000. So as such, in that scenario, we would pay the difference of the $4,000 to the client that hadn't been used by the professional company. Now, if that was a non-cat limit of the $3,000, then we would pay the remainder of the $1,000 to the client. Now, on or after February 1st, with the changes and the amended of attendant care, we'd only pay the $2,000 billed for the attendant care to the PSW company in that scenario. There wouldn't be a top-up to the client to the Form 1 amount or the SABS limits in that case. Now, after February 1st, if a family or friend is providing the attendant care services, and as everyone has indicated before about the new changes to the attendant care section of 19 bracket 3.4, the amount of the attendant care benefit payable shall not exceed the amount of economic loss sustained by the attendant care provider during the period while and as a direct result of providing the attendant care. So an example, if I made on average $2,500 a month, and because of an injured party that I'm taking care of by providing attendant care services, and I reduce my hours at work to provide that attendant care, I would submit my pay before the MVA, documentation to show what I was being paid before the MVA, and then submit documentation to show what I was receiving after reducing those hours to provide the attendant care services. So if before the accident I was receiving $2,500, and after reducing my hours to provide the attendant care services, my income was only $1,000, then I would be paid $1,500 for providing that attendant care services for the month. And that's despite what the Form 1 amount is listed at and the SABS limits, depending if that's catastrophic or non-catastrophic.
Thanks, Amy. There's a question that's come in, and I'm going to direct it to you, Michelle, just on an issue of retrospective application of this regulation. Because I think Amy's touched on their approach at their company, but I think we're seeing differing approaches by differing companies on this issue. So, and this question comes from Daryl, and he's asking, do the new regs with attendant care amount limited to economic loss amount only apply to accidents after February 1st, 2014?
Right. This is certainly a hot topic that that we've been seeing in the recent months. This regulation change is something that we didn't have a lot of time to digest before it was put into play on February the 1st. We had the suspicion, certainly at our office, and I'm sure you did as well, that some insurance companies may well try to take a position that if an accident occurred sometime between September 1st of 2010 and February the 1st of 2014, that the amendment could be applied in that case. We're talking about people, let's say as of January of 2014, may well have been receiving a $6,000 a month attendant care benefit. We had concern that come the start of March, some insurance companies may well try to say, no, we're no longer paying you the $6,000 per month. Please provide us proof of your economic losses. We will simply reimburse you for those losses. There is an unequivocal presumption in Canadian law that amendments cannot be applied retroactively if it's going to remove substantive rights. We are very firm in our understanding and our beliefs that there is no retrospective application of this amendment to accidents that occurred prior to February the 1st. That being said, time and again, as you've said, Pat, we've come to know that insurance companies will interpret regulation changes in varying ways. And even within insurance companies, adjusters will handle changes in varying ways. As we had suspected, we have seen some insurers and some adjusters taking the position that only the actual economic losses will be reimbursed for accidents predating February the 1st. Our role in that is to be proactive and to work on behalf of our clients to quickly try to overcome any of those types of obstacles. Certainly we feel very firmly that the full amount of attendant care based on the Form 1 should be paid to these types of situations. We take a role in working with the insurance adjusters, communicating our views. Hopefully it's a misunderstanding on the part of the individual adjuster and not a company-wide approach, but we are coming to know how the different companies are handling this. Certainly, in our view, we would be looking to take immediate steps towards mediation if an insurance company is standing strong on denying the full entitlement based on the Form 1 and moving it into litigation as might be necessary. We are still in very, very early days, and we're only starting to feel the impacts on these accidents that predated February the 1st. But the bottom line, no, absolutely, we do not feel that this has a retroactive application.
That's the same as our firm, Michelle. I mean, there's good authority under statutory interpretation that this would be considered a substantive change and would not have retroactive application. And I think there's a lot of companies that agree with that standpoint, but there are a few. So the one thing that they may risk is obviously some of those special awards.
Absolutely.
If they maintain that position when the authorities are pretty clear that this would be considered a substantive change, much similar to any changes to the interest component that happened previously. There is one question, and I'm going to direct it to you, Michelle, and it's just a clarification from Carmen Martino, and she's attendant care benefits calculated if a family member was unemployed at the time of the accident or self-employed, and their income varies per month or works part-time. How do you calculate that attendant care?
That's a good question, and I suspect that's something that we'll see tested as time passes. Personally, I would probably take a view comparable to how an income replacement benefit is calculated. I think we could probably look at the income earnings in the course of the past year, maybe look at an average calculation. But the legislation is silent on that. As far as someone being self-employed prior to the car accident, certainly that would be an obstacle to calculate the amount of the economic loss as it varies. I would anticipate probably, and Amy, you can pipe in, I would anticipate probably the insurance company would have some obligation to fund any kind of an accounting review that would be needed to determine the person's actual economic losses. But in doing so, the clients would have to be well warned that there would be anticipated delays in seeing that type of a calculation completed and to see the benefit begin to roll.
Amy, anything to add to that in relation to approach?
No, I would agree with that. I mean, they would probably just have to provide the documentation for it to be calculated. It might take a little bit longer, but at least there would be that calculation there to figure out what the loss is so that it could be paid out.
I'm going to move on and step away from this attendant care issue, but certainly if there's questions, we'll try to address them. But I do understand that there are some changes coming about in relation to licensing of rehab professionals. And Jim, can you help us out in relation to that area and what's coming?
Yes, Pat, thanks. We have to accept that there's fraud in the system, and we have a collective obligation to do everything in our power to get rid of it and ensure that the money in the system goes to those who need it. So the government's initiative in licensing had to deal with their concern about ongoing fraud issues about various facilities not operating in the best interests of those that they are to be serving. So there's a new requirement for those that want to be paid directly by the insurance company to become licensed. And there is an important information meeting which you may want to write down through FISCO on Friday, May 30th from 1 till 4 at room 205 North Building, Metro Toronto Convention Center. And FISCO staff will there be addressing the salient issues, including the service provider licensing framework, the role of the principal representative. In other words, they want to get to the bottom of who owns the clinics, applying for a service provider license, and very importantly, fees, because until now I gather that the fee quantum has not been released, and complying with the Act standards of practice. Now, the standards of practice will only be referencing business practices. Your respective colleges will continue to be responsible for regulating and overseeing the clinical work. And if you need further information on that, you can go to OntarioRehabAlliance.ca. This organization is putting on a webinar. I don't think they've got the date yet, which is sponsored by the Personal Injury Alliance. And then they're going through a few of the major cities in Ontario as well to do live conferences dealing with regulation, etc. So I think that brings us up to speed on that issue. Pat, you had also asked me to address in a couple of minutes or less something that may be of concern to some of the people listening, and that's around the issue of experts and specifically Form 53s. We've had a lot of change in this area as a result of some recent case law. And there's a recent case. First of all, nobody can give expert or any opinion evidence unless they're qualified as an expert in a court of law. And the people doing future care reports often consult with members of treatment teams. For example, they may go to a case manager and say, how many hours of case management per month or year do you think this person requires, and how much physiotherapy they'll ask a physiotherapist, and commonly they'll do reiteration letters. And the question comes up, do the people who sign the reiteration letters, so the case manager and physio in this example, should they be signing a Form 53? Because otherwise, the evidence of the future care planner may not be admissible, or more to the point, those signing the reiteration letters may not be permissible. I think it's too cumbersome, and I don't think a court will require it. Others at this webinar, including my partner, think that we should be doing it in all cases. So there is a real variance in that approach. We'll be discussing this further and in great depth at a program that is being put on by the Personal Injury Alliance, and this is the first announcement of it. It's October 23rd, 2014, at the Carlew, downtown Toronto, or in College. So October 23rd, we will have a future care planner undergo examination and cross-examination. We're going to have an engineer undergo examination and cross-examination. We're going to be addressing future care reports, admissibility, the reiteration letters, what's required, what you need to know in terms of testifying. A very, very comprehensive conference, which we know will be sold out early. So you may want to register for that as soon as it comes out over the next couple of weeks.
Great. I do have one question that came in, and it's back to the attendant care issue. And it was from an individual. It indicated that these new regulations don't mention anything or disregards the needs of a client who requires skilled supervisory care. So, for instance, somebody with a traumatic brain injury. And the question says, so-called professional PSWs may not have the training nor skills in managing behavioral challenges during the course of providing attendant care and basic supervisory care, which might put the patient or client at risk and may put the PSWs at risk. I think this is an interesting question, and I'm going to direct it to you, Allison, just in relation, because I know that you and Dale deal with people with pediatric brain injuries and brain injuries, but the difference between RSW and PSW care, and whether or not under attendant care, as this question is indicated, there's nothing added for people with that special background.
It is an interesting question because I think before February 1, 2014, adjusters were quite good to work with when you're dealing with a child who suffered a traumatic brain injury, and there is provisions under the Form 1 with respect to supervisory care, and if we needed a child and youth care worker or even an RSW in order to preserve the funds for med rehab for a multidisciplinary team, they were very good about having that cost go under the attendant care benefit. So I think it's a possibility still post February 1, 2014, where we could claim someone like a child and youth care worker to provide the attendant care under that particular benefit still, because it is potentially someone that's trained in that profession, dealing with that particular injury, and there is a place for it in the Form 1 in which it falls, in which there could be a calculation of 24-hour attendant care. So I think that's still very much open, and obviously I think it doesn't change much with respect to the regulation.
Thanks, Alison. Roger, do you have anything you would like to add to that? Because I know that your office deals with a lot of these individuals who suffer these traumatic injuries.
Sure. And you're right. We have countless clients who need skilled care, but I agree with Allison that nothing's changed really. We've always, since the advent of attendant care benefits at any significant level, struggled with how to stretch the dollars to provide adequate care. And the people in our audience, Pat, are the experts on this, because out there in the real world, they're the people who end up trying to stretch the dollars. There's no question that PSWs seldom have the experience and the training to deal with profoundly brain-injured people. We see them burning out all the time. We see unfortunate results. But on the other hand, a good team supporting the PSW and a very informed RSW providing supervision to the PSW can make it work to stretch the dollars. It's often because of the inadequacy of the amount of the benefit that we saw family members getting involved, so that the profoundly brain-injured person or the spinal cord injured person would get the extent of the attendant care, often 24/7 care that they needed. But you know, I don't think any of us should be under any illusion that we have a perfect system in a perfect world. We certainly do not. There is no question that even $6,000 a month is grossly inadequate for 24/7 for these profoundly injured people. But that's the way it is, and that hasn't changed, and that's something we've been dealing with, Pat, for a long, long time. I'm sure Amy sees it constantly, and you have been for years, Amy, even without the changes in February.
Amy, do you want to comment on that at all, or?
Well, in the past, yeah, we have used portions of the attendant care with RSWs and that to support the needs of these clients, and we'll continue to do so after February 1st as well. If it's a required need and it's a specific specialty, then it's definitely something that we would look at.
And it leads me, a lot of our people joining us on the webinar are out there. They're doing the treatment plans. Some are providing the attendant care, getting it in order. We have case managers. And Amy, we have you here today from your company. You've had over 10 years of experience as a senior adjuster. Could you give tips on how to perhaps expedite matters and avoid delays in getting payments and approvals done within the system? If you were able to offer some tips, could you share those with us?
Yes. So I receive copious amounts of paper, and I put together some tips about submitting for expenses or the expense claim form, saving time for everyone involved, and hopefully getting money back in people's pockets a bit faster. So it really helps if the items that you're submitting tell us a story. So if the paper can tell us a story of what's currently happening, then we can understand a bit better and get those payments out faster. So I put a few things together about maybe some tips and examples. So if we're dealing with economic loss of a family member or a friend who's providing services for either attendant care or housekeeping, for that matter, if they could be attached to the application form, like the expense claim form, and label like the the pay received before and now what it is afterwards, so we have a clear indication of where that loss is. And that way we can calculate it a lot faster and get that out. Also, if it's someone's taking unpaid leave from work, if they want to attach the letters from their employer, from the HR department, indicating that span of time that they'll be taking that unpaid leave, that would be great, and also indicating what the loss is for that period of time. Also, if there's multiple receipts that are being sent with the expense claim form, if they could be either maybe taped to the back of the sheet. Sometimes when they come into our offices, they may not all be stapled to that expense claim form. Sometimes they're just stuffed in the envelope, and things we hope don't go missing. But if they're taped to the back, then we know it's exactly to that claim form. If their client has extended healthcare benefits, and if there is claims for ambulance services or specific devices, if there is extended healthcare coverage, if the explanation of benefits could be attached to show either there is no benefits from the extended healthcare company, or maybe there was a portion and we need to pay the difference, or showing that there's no coverage at all and we need to pay that full amount, that's very helpful and sort of speeds up the process for those types of claims. Also, if there's visitors' expenses, and there's a lot of them, and it's also sent in combination with medical expenses, if all of the visitors' expenses could be listed on one form, and also indicate who we should be paying, if it's someone else other than the client for those visitors' expenses, that could also be a bit of a faster way of processing those items. Also, if, in all of the med rehab expenses listed on another form. Now, for treatment plans and OCF-18s, we know that HCI doesn't have the most specific codes, and sometimes other is often listed in the goods and services. If on the last page of an OCF-18 or in the space provided underneath, if it could be listed what the other code is actually, what the item is for, maybe explaining a little bit about the request, even on a page after the signature portion of the OCF-18 for faster decision making. And I think that's about it.
Thanks, Amy. I think that's extremely helpful. Alana, I know that you head up John McLeish's accident benefit team, and I know that timeliness of getting things approved is essential. Can you as well offer any tips in addition through what legal officers can do, or what health professionals can do in dealing with law offices on trying to expedite matters and avoid delay?
Sure, absolutely. I think most of all, communication is key, and Michelle, I'm sure you can agree with me on this one. We always want to help adjusters understand where we are going with the rehab. And if, for example, I get these calls all the time from healthcare professionals, they want to submit a treatment plan and they're not exactly sure if it's something that they should be submitting. We always suggest that you call us first to get our opinion, because then we do receive calls from the adjuster saying, this treatment plan was submitted. Do you know what it's for? Do you know why? So I guess it kind of, there's no delay in that sense if we already know what it's for, so we can either communicate that to the adjuster directly, or we can say, we think this is a great idea, go ahead and submit it, and if there's any questions, they can call you directly. in terms of unusual treatment plans, if there's something that you're submitting that, again, you're not sure of, let us know again. We'll give you our opinion, and we can always speak to the adjuster and let the adjuster know. And Amy, I don't know if you can agree with me on that one. If there's unusual treatment plans that, we're submitting, if we can just, let you know first, does that help the process?
Yeah, it does, definitely does. As long as, if there's discussions about the explanation as to the medical need for the items, also, sometimes some service providers, they put a page on the back
Right.
outlining all of the items. It makes the process much faster.
Okay. Just one other thing. Do you prefer that, sometimes the healthcare professionals will give you a call before the treatment plan is submitted?
Actually, a lot of providers do call, especially if some of the items might be a bit different in nature or maybe something that we haven't seen before. It's wonderful. Sometimes paper can only tell us so much. Sometimes that phone call, understanding what's happening with the client right now, where their status is, and the recommendations for those goods or services, it makes a big difference.
Okay. Michelle, do you have anything to add?
Nope, I think it's well covered.
I've got a question for Amy, if that's okay.
It's allowed, Jim. It's allowed.
If there is an economic loss from one family member, Amy, and the attendant care in a CAT case is being provided by a large group of family and relatives who don't have independent economic loss on their own, pre-February amendments, do you pay the entire Form 1?
So if there's an economic loss from one family member.
Right.
And then we have that documentation.
Yes, so accept that that's been established.
Yeah, and then.
Maybe you'll need to move up a little bit, I think.
Oh, sorry. Yeah, if the economic loss is substantiated for that month from one family member, then pre-February 1st, then we would pay the Form 1 amount in accordance with the SAB's limits.
Right, so even if some of that attendant care is provided by those that can't establish economic loss, because as long as there's an economic loss.
Yeah.
You agree with that? Okay, great.
For that period of time, sorry,
Right.
yeah.
And the last question, which is on a different note, but another one that I have come across, and it's not with TD. If a client's family, let's say the client, I have a client who's Chinese, doesn't speak any English, and she can't get her family to come home from China for political reasons, can't get visa or whatever, and my client needs some support from that family and chooses to go to China to travel for that, would you pay her travel expenses as visitor expenses? Put you on the spot here.
I think when I'm reading the SABs for that portion of visitors' expenses, it's typically talking about family visiting the client while they're in treatment or while they're in hospital. That's typically, I think, where the idea for the visitors' expenses was going. We have had treatment plans submitted for a scenario such as this.
And you've accepted them?
I have in the past.
Thank you.
Certainly, I've had cases as well, Jim, where they've paid for those expenses as a visitor's expenses. And Michelle, do you have anything that you can add from your experience?
In my experiences, I've had situations where the travel is paid either as a medical benefit or as a visitor's expense. And I think, as Alana mentioned, at the end of the day, it really is about open communication between the client or the representative and the insurance adjuster, because in reality, we're all good people trying to work for the good of a client. And if we can establish the rationale behind the request, and if a good case can be made to support the request, more often than not, we can come to agreement with adjusters. And the SAB's, the Statutory Accident Benefits Schedule, is black and white, but there's always room to wiggle around between benefits, and it's really just about having those open discussions and to try to come to reasonable solutions within the benefits that we have.
That sounds sage. This question comes in, and actually it touches on, I think, a lot of our discussion, especially with attendant care and the changes, and as well, obviously trying to avoid delay. But it seems to me and everyone else that there's a lot of things that have to happen before people are entitled to start getting paid their attendant care once they show these incurred expenses. and really there's increased delay likely within the system on trying to get that information to Amy and others in order to quantify these benefits. What, if anything, is and I'll put it to you, Michelle, and perhaps Jim and Roger, what, if anything, are you doing in relation to that delayed period right after the initial insult? But here now you've got a family, they have no income coming in, they have attendant care needs, and now you've got this delay in relation to getting that going. What, if anything, can be done in that regard?
Right. It is really about being as proactive as possible in managing the claim. From the very, very early meetings with families, if they are adamant that a family member is going to provide the care to the loved one who has been injured following a discharge from hospital, there are steps that can be taken immediately to try to pull together the information that's going to be needed to establish the claim. Certainly having the loved one go to their employer as quickly as possible to get the letter which indicates the leave of absence and the details of the pre-accident employment earnings, pulling together pay stubs and having that claim set and ready to go. There absolutely can be a delay, and just as an example, attendant care is paid as an incurred expense. So currently we're in the month of April. If we were to submit April expenses on May the 1st, the adjuster could then in turn take up to 30 days to issue the payment. So now we're looking at a person who has not received income for the period of April, has had to wait all the way through until May, and maybe by May 30th will receive a payment of an attendant care benefit, which is completely not acceptable for a family who's already financially strained. One thing that we've been doing, again, coming back around to this idea of communication, open communication with the adjuster, is to be proactive in managing the submission of expenses. I think there's obligation on both sides, from the legal perspective, but also from the adjuster's perspective, to be prompt in processing claims, despite this idea that the adjuster has up to 30 days to make the payment. I've successfully negotiated with adjusters on a few cases already to submit expenses biweekly, and the adjuster in turn will issue immediate payments, almost to see the attendant care being paid as, almost in a sense, as a paycheck. I've also successfully negotiated with another very, very caring adjuster for the expenses to go in every single week with immediate payments. So it's just about having those conversations.
Great. Actually, I'm going to put this question to you, Alana, because you're on the front lines as well on a lot of these issues with the Form 1s. And the question is, are you seeing any companies insisting on paying only the Form 1 hourly rate to an attendant care company, regardless of what the total amount of the Form 1 is? So they're trying to match the rate to the activity.
I personally haven't come across that. Michelle, I don't know if you have, but I haven't seen that, no.
This is something that we've been seeing with more frequency in recent months, and I'm not sure where the trend is coming from or why. It's alarming. We all know that personal support workers don't work for the hourly rates which are listed in the Form 1s. I think it's a challenge that is going to have to be worked at to try to find solutions. Blessedly, it's not something that we're seeing with great frequency, but I would say it's possibly an issue that's on our horizon.
Great. The next, and thanks Michelle and Alana on that point. The next question comes to you, Amy, and it comes with a preface that Amy happens to be one of the best adjusters I've ever worked with, which is nice to see. But do you have any recommendations, Amy, as it relates to perhaps new adjusters coming into the SAPs and having to deal with all these new issues, on perhaps some pointers that you could make in relation to those new people coming into this system, and what, if anything, can they do to help them get up to speed?
So sorry, it's
just for new adjusters who are less experienced. And I guess the question is it advisable for them to go and speak to supervisors if they're perhaps not understanding a particular issue? Or what other avenues are available to them if they're new and require some assistance?
Yeah, well, yeah, of course, speaking with their management, also speaking with their senior analysts who, have been dealing with certain situations for a number of years of maybe how to approach a scenario or have maybe different views or different ideas of looking at a topic or especially right now that with all of the new changes, we've had many changes over the past few years and few months. And every time there's a change, there's a lot of new experiences to go with that. So,
Great. I'm going to back to you, Allison. Previously, we were talking about attendant care and people with specialization with individuals with greater needs as a result of traumatic brain injuries. And the question comes wouldn't a child and youth care worker be seen as a rehab service rather than as an attendant? Are you able to address that question?
I mean, it could be seen as both, and I think that's where Michelle's talking about. The SABs are black and white, but there's a lot of gray area. And when you look at, it's what Roger and I were saying, when you look at the Form 1, there is a provision in there for supervisory care because of behavioral or safety issues that may arise, and that's a classic symptom of someone that has suffered a severe traumatic brain injury. And so especially if you're dealing with pediatrics, you know that early intervention is very important. The child who suffers a traumatic brain injury is likely going to use almost all of those benefits in the med rehab. So if you can be creative, a child and youth care worker truly can offer the skills under the Form 1 of supervising, providing safety for that child on a 24-hour basis if that's a requirement on the Form 1, and that allows you to preserve the other benefits in medical rehabilitation for service providers that are going to treat that person with an acquired brain injury that won't necessarily be able to fall under Form 1. So I would say they could fall under both. But in a case where we're looking at potentially parents that aren't going to be accessing an attendant care benefit anymore, my advice would be going forward is if we can have that child and youth care worker or RSW be paid under the attendant care benefit if they require that supervisory care under the provisions of the Form 1 for safety, then that's a possibility as well. And I don't think the changes from February 1, 2014 change that in any way of where we've done that before or after.
Pat, maybe if I can take a second just to add another thought. One of the strategies, if you like, or approaches that we have found works wonders, and I credit our accident benefit specialists, who are all former insurance adjusters themselves, for this. I suspect you do it as well, Pat, in your office. We find having a team meeting of the rehab team that is preferably hosted at our office by our accident benefit specialist, where the adjuster is present, works wonders. And the reason it does is that, I'm not talking about the odd adjuster who, doesn't agree with anybody on the time of day, but those people are at a minimum. Most adjusters are trying to do a very, very difficult job. They're trying to do the best they can within the meaning of the contract as they understand it for the insured. But if you give the adjuster the opportunity to sit at a team meeting and hear reports from all of the providers that explains what each of the providers is trying to achieve, and if difficult issues like attendant care are addressed in a way that is case-specific so that the adjuster can understand what the needs of his or her insured really are. And if, as a team, everybody can work collectively on figuring out how to make the money stretch and last so that adequate rehab and adequate attendant care is provided, the results can be quite extraordinary. And experienced people working in this way realize that it's wrong to think of the rehab money and the attendant care money as two great divides, or there being one great divide down the middle. It's all money and funding that should be brought to bear in a creative way to make supervision, attendant care, and rehab work for insureds with special needs.
Roger, I think your point is excellent, and I think it goes back to what everybody has been indicating on the panel about communication, keeping the lines of communication open. And I only want to just throw in one example that on one of our team meetings, we had the adjuster there. It was an issue of housing and the appropriate housing. There had been 3 recommendations, and it looked as though the team was going with one specific recommendation. And the adjuster had been very experienced, had indicated, have we considered this other option? And we all went and took a look at the other site altogether. We took a look at it, and it was the better option, and it was best for my client. And we all went there, and that's where the housing recommendation went. And that was specifically because I had a very experienced, knowledgeable adjuster in that room. And I can't express enough that that is such a helpful suggestion on these types of claims. I'm going to, the next question, and in fact, it's if patient, and it's under the minor injury guidelines, and as we all know, the large portion of injuries coming through this particular system are minor injuries. They do amount to the most quantifiable amount of injuries that come through the system. So this question is, if the patient's injuries fall under the minor injury guidelines, and I'll put this to you, Amy, do they qualify for attendant care and housekeeping benefits? And then, Amy, I'm not, I mean, I can put it to Michelle or Alana, but clearly they don't. In relation to the minor injury guidelines, do they qualify for attendant care and housekeeping benefits?
Not under the minor injury guidelines. No, and then there'd also have to be optional benefits. You know, if it's not catastrophic, but there's no attendant care or housekeeping.
And you had mentioned just optional benefits. Can you just explain briefly what optional benefits are?
So optional benefits, there's additional purchases that a client can make for specific things, even for income replacement benefits, like a higher weekly amount, or for medical rehab limits, and also housekeeping and caregiving that can be purchased as well. So that if there was a client who is not a minor injury and not catastrophic, and if they had purchased the optional housekeeping benefit before the accident, then that would be something that they could be eligible and entitled to.
And thanks, Amy. Roger, this is a question to you, and it's back to some of the areas that Jim was touching upon on reiteration letters. But could you elaborate on the possible requirements that a professional must first have to be qualified to give expert opinion? And that would be in reference to opinions where there's a recommendation and a care cost plan by a health professional.
That's a good question. And as Jim said, our firm, McLeish, Orlando, and Thompson Rogers, the PIA firms, have organized this experts conference because these issues are so hot and so timely for the fall. So this is a sort of question that will be looked at much more in depth. But here's the, first of all, the broad context of it. It's clear that experienced lawyers in our field are finding that future care plans, life care plans, whatever you want to call them, are presented in a much more persuasive and credible way if the treatment providers who are consulted in the preparation of that plan come and give evidence to support the plan. There's even the odd case out there where judges have said that without that evidence, they're not going to allow the plan to be expressed to the jury, but I don't think that's our law. It's not quite that bad. But the result of this evolution in of the approach that lawyers like us are taking is that you, as treatment providers, are going to find that increasingly you're asked to provide this kind of evidence. And that's why we're putting on the conference, because you may have this happen to you, not once, but on frequent occasions. So the question Pat's putting on behalf of one of you is, how do I qualify as an expert? Well, if you are providing treatment, you are, by definition, an expert in that field, or you wouldn't be providing the treatment. Now, you might have a different kind of expertise than a physiatrist who knows what the impact of that treatment ought to be or will not be, but you're still an expert to the extent that you have been trained to provide that care, and you're an expert in the result of the application of your care to the outcome for the patient. And what we are finding is best, I'm sure any of the lawyers in our two firms, is that we obtain a short letter from the treatment provider, which I understand are being referred to as reiteration letters, because you're reiterating what you've told the life care planner in advising him or her on the contents of the plan. You're reiterating that advice in the form of a short letter. I believe that so-and-so needs physiotherapy so many times per month and will for the rest of his or her life, plus additional sessions during exacerbations and that kind of thing. That's your reiteration letter. And either attached to it or as part of that letter should be a statement of what your experience and your qualifications are. And Pat would call you as an expert witness and say to the court, I'm tendering John Smith as an expert in physiotherapy, and ask you questions to elicit what your experience and training as a physiotherapist is, and then the judge would accept you to testify as an expert in what you do and have done for your patient. Does that answer your question, Pat?
It does, Roger, and I think that's extremely helpful for anybody trying to understand why we have experts and the rules that apply to experts in giving opinion evidence.
Pat, if I could just weigh in on that, it really is a difficult area for all of us, and it's changing. We're waiting for the Court of Appeal to render a decision in two cases, which are going to be heard together in September. But the last time I was in trial, I had a future care expert who had done these reiteration letters, and over the objection of the defense, the judge said that the life care planner was entitled to give evidence on the nature of her discussions with each of the people from whom she got reiteration letters without having signed Form 53s or specific evidence from all of these people that signed those letters. So I think the prudent course of action, as Roger suggests, is to have these Form 53s done, and that's why all of these people out there, you're going to be inundated with requests from our firms for these forms. But it really is, I guess I would just leave you with the thought that you'll have to discuss it with the lawyer having carriage of the case, because there's all sorts of considerations that have a part to play in it.
Yeah, I agree. I agree with Jim. We have the Form 53s on our reiteration letters requested just in case. I mean, unfortunately, it's an added step to the process. It's an added cost in a world of proportionality where they're trying to reduce costs. but I think it's best to be safe than sorry, that's for sure. It ties in a bit on this it's not so much experts, but being able to give attendant care services. And I guess this question is to you, Amy. Who would be qualified to give attendant care under this new regulation, in the sense of what is the qualification that the TD would look for, perhaps, for an attendant care provider?
Well, I think, there's a lot of companies out there that provide services for attendant care. So if it's a professional company of some sort, I guess, as long as they're bonded and insured, then, that would be sufficient. Like we discussed before, with regards to the specialized needs, sometimes we have to have specialized nurses doing part of that attendant care, maybe a smaller portion. So sometimes it's broken up between multiple different types of care workers, and it could even combine, a family member, a PSW, an RSW, and a specialized nurse as well to make up that monthly amount of attendant care. So I think it's more about what the needs of the client are, and finding a good fit with that service provider. As long as they're qualified to provide that care, that would be sufficient for submission of attendant care.
Great. And that Amy, leads into the next question that comes from Ellie Lapowicz. And Ellie said that she's heard of situations where family members, not meeting the incurred definition, set up a business and then bill the adjuster for the attendant care that they provide. Is that something that anybody's seen? Would it be considered acceptable? And at the end of the day, would that be a taxable benefit as well in the hands of the providers? Anybody want to try to jump at that question?
I'll take it.
Yeah, Michelle?
I think it's creative. I haven't seen it by any means. I am typically an optimist. I would suspect in this case, though, that adjusters would not accept that as being an attendant care expense. The legislation states that if a professional is providing services, attendant care is payable. The incurred expense has been met. But if it's a family member, they must show an economic loss. This is sort of blending, I think, in some ways, or an attempt to blend the two. But for a professional, they must be providing the attendant care in the course of the employment that they would have been engaged in prior to the accident. So to set up a business post-accident to say, I'm an attendant care provider, I simply don't think that would be accepted.
Anybody want to add to that at all? It's creative. I mean, absolutely creative, and I think it's really an attempt to become a professional caregiver post-accident, which does pose difficulties on the post-accident aspect.
Mm-hmm.
That I'm very negative on that being accepted by companies, and I have a hard time imagining that a judge on a trial or a motion would support that kind of attempt. I hate to say it, but it's borderline fraud. It's just not legitimate. We've had situations that are different from that, but have some similarities, where spouses of injured people are trained as PSWs, and they provide the care, and I believe the insurer is accepting that. But unfortunately, in the real world, the rates that these people are paid are not great, and it's pretty hard to get it to the $6,000 level.
Yeah, and I agree with you, Roger. It's again one of these situations where they're trying to skirt around the legislation, and it likely would not be acceptable, I think, by any judge listening to someone attempting to do that. I'm going to bring in a new subject because it is pertinent to where things are going, and I do believe it has legs. the former Justice Cunningham has done a report and a review of the dispute resolution model here in Ontario, and that was following consultations from the health profession, but as well as various legal associations. And he's put that report to the government with specific recommendations, and this likely may very well lead into new legislation as it relates to the model that we're going to move into under the dispute resolution system. And just generally, I know that we've all been watching this closely, and I know, Jim, that you're speaking on that in an upcoming conference within the insurance industry. And I thought it would be good if we could just touch on where this is going and what people think about it. Briefly, and just some of the overview is the new model to which Justice Cunningham has recommended and that they're looking at is one where they deal with proportionality and based on the nature of the claim. And as well, it's also a system where they're trying to make things move in a more timely progression in order to enhance treatment. So, for instance, they've set up a system where they have settlement meetings which combine the mediation process and the pre-arb process together, almost like a triage. And if the thing isn't resolved at that stage, it moves into a new stage where you could have a paper review for those claims that are $10,000 and less, for instance, treatment plans, where it's done simply by a paper review. The decision is made, rendered, and it moves out of the system. And then you could also have another avenue where you go into an expedited hearing, which is a half-day hearing on those claims that are over the $10,000, and then you can have a full hearing on the more substantive type claims where you have perhaps catastrophic an issue or a post-104 test. But the whole idea of the system itself was meant to move things very quickly through the system. I believe that the proposals will enhance individuals accessing treatment as opposed to them getting caught within litigation, and as well people on more minor claims lawyering up, as they would say. So my first question, and I think I'll direct it to you, Jim, about Cunningham and these recommendations and the new system. What, if anything, or thoughts do you have on that system, and what implications, Jim, do you think it may have on health professionals that are running companies dealing with treatment?
So we understand that the nuts and bolts of Justice Cunningham's report have gone to legislation and passed first reading, and that I think tomorrow, in fact, they're hearing representations from various interested groups at Queen's Park. One of the primary recommendations is to do away with the right to sue through the courts for claims. And of course, often the claims at stake in the SABs are critical to the long-term economic health of our clients. So whether a person's catastrophically impaired, or whether they're entitled to post-104 benefits, or whether they're entitled to 27-hour attendant care, this report says you are restricted to going through this new tribunal, which is not going to be run through FSCO anymore. And I think that's bad for all sorts of reasons which probably are not of great interest to this audience. But what may be of interest is what is going to happen with these treatment expenses. So one of the streams, which is going to be the paper review, is those whose claims are worth less than $10,000. So that would be the usual treatment plan for physio or OT or whatever the case may be. And we're going to get responses within 30 days. And I don't think that we're largely ever going to see legal representation for those claims. They're subject to an internal appeal process within the insurer, which I can't see as being anything but a good thing. And hopefully insurers will accept that responsibility and have an independent review process within their own company. And I think that we're going to see those people needing treatment getting it much sooner, because there is an expedited process. It certainly isn't a perfect process, but you can't have an expedited process and still have lawyers involved in and oral testimony from people. It just doesn't work that way. So I do think on the smaller end, the benefits for immediate treatment are probably going to find its way in the hands of those that need it. So I applaud that report for that, and I think that's going to be helpful to know, I think, for the members of today's audience.
Thanks, Jim, and I agree. I like Cunningham's recommendations, but the one recommendation about taking certain claims outside of the court system is a real issue, and ought to be something that they not consider passing. And before I pass it on to you, Roger, to comment on that, because I know you have strong thoughts as well on that particular issue. Jim mentioned about government hearings. There are government hearings on that issue, and I'll give you the phone number where they're asking for if anybody wants to make any oral submissions to the government. That is tomorrow, and the contact number at the government is 416-325-3515. If there's anybody who's looking to speak on that issue at the clerk of the committee. And the bill is Bill 171 that they're considering. Roger, if you have any comments on this one aspect about the right to sue and bringing certain accident benefit matters into the court.
Sure. I'd love to make a comment specifically if you happen to be from the government legal office, if you're in any way attached to anybody who's making any decisions around this system, please hear me out, because this would be a disaster for people who've been injured, who have suffered significant injuries, and let me tell you why. We probably, in our practices, certainly in my office, I can attest to it, in my own practice, probably 50% of the people I act for have two lawsuits. They've got a lawsuit against the people who caused the accident, and then they've got a lawsuit against their own insurance company. And the issue is whether or not they are catastrophically impaired, and as Jim said, whether or not they're entitled to attendant care benefits at the catastrophic level and med rehab at the catastrophic level. The tort lawsuit is the small lawsuit. It's about $1 million usually at most. The issue over catastrophic impairment is a $2 million plus lawsuit. It's the big one. The problem, if you put those issues into a system outside of the courts, is that there will be issues being determined which affect each other in different places and at different times. Now, I suspect in our two firms, certainly for myself, I never go to arbitration over these issues because I want them all in the same place. I don't want my client to incur the expense of having to have hearings or trials, whatever you want to call them, in two separate forums. And now these cases are resolved by setting the accident benefits issues down for trial with the tort issues, so they're all going to be reaching resolution at the same time. The lawyers for both or all insurers are at the same mediation table facing the same timing, and these cases get resolved in 99% of the cases. It's going to really throw a big monkey wrench into the works, and this one provision has to be taken out of this bill. I think I may have sounded like Don Cherry there.
You're scaring me, Roger. No, I think you've made your point well, and it's something that obviously you see as having a fundamental impact on a lot of individuals. Outside of the right to sue in those cases that go to court, though, we are looking at a new system that Justice Cunningham is proposing that is potentially more user-friendly, more timely, and with the paper reviews, hopefully going to allow people to access treatment very quickly as opposed to being held up into whether the arbitration or the court system. I guess my question, part of the recommendations, Amy, was that one way that they were looking at facilitating the timeliness of payments was to have internal reviews within the insurance companies when they're looking at a particular benefit, and to have a process that is used to do an internal review right at the offset. I guess my question is, what, if anything, do you think of that? And do you think that would be effective, at least in certain claims initially being considered for denial?
Sorry, could you maybe elaborate a little bit for me on
so
what you're...
Justice Cunningham, when he was making his recommendations, had envisioned a system where perhaps there was a particular benefit being denied, and that he had made a recommendation that each insurer should establish an internal review process and be required to inform a claimant how to access it following a benefit denial. And each insurer will determine how their internal review process is to be structured, and they have to give a certain response to the individual within a specific set amount of days.
Yeah.
And I'm sure it already exists.
We tend to already have that in place, I think. I think, though, maybe more education before of how to claim for items. I think sometimes that's where maybe there's a bit of a downfall. Initially, I think in the OCF1, when that goes out, it's just a very brief blurb on the front about, what each item is for in that application package. Conversations with the clients and health providers and everyone involved, indicating, what benefits are available, how to apply for those, maybe clear expectations as to what should be submitted, what we're expecting to be submitted in order for it to be payable, right? I think sometimes if it's outlined very clearly in the beginning, maybe after the conversations with everyone, a letter is written outlining, this is some items that you might be eligible for. This is how to claim for them, and we'll follow up with you to make sure that you understand how to complete it, and then go from there. So, it definitely needs to be looked at and reviewed, as always. There's so many different changes all the time, and procedures change as well. I think that all of those things need to be looked at to make the process more efficient.
Great. Thanks, Amy. Jim, I'm going to throw this just one over to you. Or actually, Allison, I'm sorry, because Allison, on this one of the recommendations, and I think it's going to have legs, is the settlement of future medical and rehabilitation benefits should be prohibited until 2 years after the date of the accident. And we know that right now it's a prohibition of 1 year. They're extending it to 2 years. What, if anything, do you think that will have an implication on people providing treatment and health professionals who are providing medical and rehabilitation treatment?
What effect?
Yeah.
And I feel free for Jim or Roger to jump in, but I think in terms of our cases at our firm, I don't think it will have an effect. I think our philosophy is, whether it be an acquired brain injury, whether it be a serious orthopedic injury, it takes 18 months for someone to reach that maximum recovery, possibly, and we wouldn't consider settling any med or rehabilitation benefits until after that fact. So I think in terms of how it'll affect the treatment team, I don't see it having a huge effect. I think it actually is a good provision that protects insureds from potentially settling their claim prematurely when they don't have a good grasp on their prognosis and what they're going to need in the future.
On balance, Pat, I agree. One of the things that I find very distressing is taking over a case from someone who really doesn't know what he or she is doing, who has settled the accident benefits claim quickly for some inexplicable reason, accepting that the client is not catastrophically impaired, so settling them on a non-cat basis way too cheaply, way too soon, losing the potential for all kinds of funding that's required for treatment or attendant care, and possibly a cash out down the line. So generally speaking, I think it's a good provision. The one concern I do have, and it's too bad there isn't an exception in there for special circumstances, sometimes at-fault people do reach a plateau relatively quickly, and you know that nothing is going to change. There's going to be no further improvement, and it's the only amount of money that that poor person's ever going to have, so you want to try and do the cashing out or lumping out with the insurer as quickly as possible before too much of the money is burned up. Waiting 2 years sometimes can be costly, and that's my only concern about it, but generally speaking, I do agree with Allison.
Great. Well, to the panel, thank you so much for today. We are wrapping up. I did want to thank everybody for joining us. This webinar is going to be made available online on our respective YouTube channels through McLeish Orlando and Oatley Vigmond, and that will likely be up within the next 2 weeks. I'd also like to, as Jim's already indicated, invite you to join us at the Sunnybrook Conference that's coming on June 12th at the Carlew. Also save the date for the Personal Injury Alliance Expert Conference, and that's on October 23rd. And then we also have our next Practical Strategies webinar on October 28th. On behalf of everybody on this panel, and especially you too, Amy, for coming and answering questions from an insurer's perspective, thank you so much, and thank you all for watching. Thank you.